Your attorney calls you to tell you that the defense has just made a great settlement offer, and he highly encourages that you accept it. What happens if you turn around and say, no, I'm not going to accept it? You want to know what happens? Come join me on this walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. What happens now is that your attorney has an obligation to go ahead and relay the fact that you are rejecting the defense's settlement offer. Now, your attorney thinks that your case should be settled, and this is a fantastic, fantastic result, and that you're never going to get better money or a better offer at any time afterwards. Now, do you have an obligation to go ahead and accept your attorney's recommendation? The reality is no, that you as the client, you have control over whether or not to accept any settlement offer. It is your ultimate decision about whether to accept an offer. The question then becomes, is your decision an intelligent one? Is it based upon logic and reasoning? Is it something that you are making an emotional decision on as opposed to logic and reasoning and percentages? You know, many times when an attorney makes a settlement offer and the client rejects it, many times they do it based upon a gut emotional level. They have an emotional attachment to the fact that this was done wrong to me. This person should pay. I want to go to trial. I want them to see exactly what happened. And yes, I recognize that that is often the case. There is a clear emotional attachment to everything that occurred. And how dare they make a settlement offer at this late date? And now they get all righteous, and now they get upset that it's taken such a long time to get a settlement offer, a real settlement offer going. And you turn around to your attorney and says, I don't care what this offer is or how good the offer is, I'm going to trial. I want to tell my story. I want members of the community to listen to this, to my story. I want the judge to hear my story. I want the public to know my story. If I go ahead and settle this case, now it gets put under the rug. Nobody hears about it. I won't be able to publicize it. And guess what? Now I just go on my merry way and that's the end of it. I'm not having that. Can you as the client go ahead and do that? The reality is yes. You have the ability to go ahead and reject any settlement offer that is made. Now, is that a wise decision? The answer may be no, it's not necessarily a wise decision. The best person to advise you about the settlement offer would be your attorney. He has been with you every step of the way. He has been with you through the years of litigation. Hopefully, in all likelihood, your attorney knows your case inside and out. He knows the strengths. He knows the weaknesses, the pitfalls. He knows where you are likely to stumble and get into trouble if your case goes to trial. He may even tell you that you have a weaker case than the other side does. In that instance, you are likely to lose your trial. And now you have problems because now you will never see a dime if you lose your trial, even if you try and appeal it, even if there are grounds to appeal it. So if the attorney gives you logical, well thought out reasons as to why he believes this is a great settlement offer, and after extensive settlement discussions, he knows from the defense that they will not offer another dime. Now you, as the client, have to make an educated decision about whether to accept this offer. In a situation where the client outright rejects the great settlement offer, now we may turn around and use an analogy about whether or not they like to gamble. And many times the client will turn their head and wonder, what do you mean? What do you mean, do I like to gamble? Well, when you go to Las Vegas, if you go to a casino, if you now have $1 million and you gamble it all on one hand of blackjack, what are you doing? You are gambling. You are hoping upon hope that your set of cards will beat out the dealers. And if that's the case, great, you're going to win big time. If you lose, guess what? You've now lost your $1 million, all because you thought that you had a greater chance of winning than the dealer did. Well, guess what? You are doing the same exact thing when you reject what your attorney believes to be a great settlement offer. Now, a great settlement offer doesn't mean you're getting every single thing that you demanded or wanted. That's not what it means. It means that based upon all the facts of your case, based upon all the strengths and all the weaknesses, your attorney has come to the conclusion that this is an excellent settlement offer and you are unlikely to get another dime more. So now you have to weigh that against going to trial and gambling whether 6 members of the community will, number one, recognize that you are right and that the people whom you are suing were careless and negligent, and that their carelessness was a cause of your injuries. And not just that, you are gambling that they will recognize, these 6 members of the community known as the jury, will understand that your injuries are significant, disabling, permanently disabling, and will last you for the rest of your lifetime. And importantly, that they recognize that the value of those injuries far exceed the amount that you are currently being offered. Because when you risk that gamble, when you risk that bet, there is a possibility that they may never even get past the first part that they have to answer, which is, was the defendant or were the defendants careless? Were they negligent? If it turns out that they were not, the jury feels that they were not negligent, they never ever get to decide whether or not to give you any money, and if so, how much. If the jury does reach a decision in your favor that the defense was careless, guess what? Now they have to answer the second question. Did the defendant's carelessness, was it a cause of your injury? We call that proximate cause or causation. If the jury turns around and says, no, we don't believe that whatever was done wrong caused you this harm and injury, guess what? You lose and you get nothing. And the jury never, ever gets to consider whether to give you any money as compensation for all the harms, losses, and damages that these people caused to you. So they will never get to that point if they decide that there is no connection between the carelessness and your injuries. Now, let's say hypothetically that the jury does believe you, and now they determine that yes, the people whom you have sued were careless. And now they also decide that that carelessness was a cause of your injuries. You may be disappointed and hope that your bet pays off because the jury may not agree with your assessment or your attorney's assessment of how much your injuries are actually worth. So even though they may have gotten to the point where yes, they believe the people you sued are careless, and yes, that carelessness was a cause of your injuries, and yes, your injuries are significant, they may have the understanding, the collective understanding amongst all 6 members of the jury, that your injuries really are not as bad as you claim them to be. In that instance, they will likely give you less money than what you perceive your injuries are valued at. In that instance, you will be sorely disappointed to see the discrepancy between the amount of money that the jury actually gave you compared to what you could have gotten had you taken what was behind door number 1 when the defense made you what your attorney said was a great settlement offer. So you are really gambling and hoping upon hope that the jury recognizes the case your way, recognizes that you are right and the defense is wrong, and recognizes that the value of your injuries are significantly more than clearly what the defense was originally willing to pay. There are some instances where your bet, your gamble will pay off. But if that happens, I can guarantee you that the defense will turn around and do everything possible to appeal that particular verdict, which now leads you down a different path and with different options and different ultimate outcomes that could occur. So before you even get to that point of getting to a trial, you have to weigh very carefully any settlement offer that comes in. You have to listen to your attorney's recommendation about whether or not he believes this is an appropriate settlement. And then you as the client have to determine the ultimate decision about whether your case should proceed to trial and take what's behind door number 2 when the jury comes back with their verdict, or do you take a known, definite quantity behind door number 1 and what your attorney tells you is a great settlement offer? So why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of cases work in New York. You know, I recognize you're likely watching this because you wanted to see the beautiful beach. No, I realize you're watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.